Committee will come to order. Today we will hear from 3 judicial nominees. Jeremy Daniel, nominated to the Northern District of Illinois. Judge Brendan Herson, nominated to the District of Maryland. And Darrell Papillon, nominated to the Eastern District of Louisiana. Congratulations to the nominees and their families. The nominees before us today have each received blue slips from both of their home state senators, including Mr. Papillon, who is the support of both Senators Cassidy and Kennedy, both here today. I'd like to thank these senators for working in good faith to identify nominees for vacancies in their states. The blue slip process has a long history, but there have been instances of success and failure in that process. We have an illustration of success today, and we're happy to see evidence of it at the committee. There are many members, Senator Graham and his predecessor, Senator Grassley, have demonstrated that they can work with the White House of another faith to identify well-qualified nominees who are acceptable to members of both sides of the aisle. I might add parenthetically that during the 4 years of President Trump, I was able to fill every vacancy by sitting down with the White House and negotiating, basically giving and taking back and forth, and I believe excellent nominees came out as a result. We have several issues still pending before the committee that I will not go into at this time, but I hope that I can urge all of my colleagues on both sides of the aisle to try to find common ground when it comes to these issues. Now for today's panel, we have several senators who've joined us for introductions, and I'm honored to be able to introduce a nominee from Illinois, Jeremy Daniels. But first, let me say to Senator Graham, welcome back from the Middle East, and I'd give you an opportunity for opening remarks.
Thank you, Mr. Chairman. I'm glad to be back. I think we're going to have a markup here fairly soon about a lot of bipartisan proposals regarding social media. Many of the members here have worked together to find solutions to the problems that face America. So I look forward to working with you on that and see if we can, start the process for the Congress as a whole. In terms of the blue slip process, we're trying very hard to be reasonable. We may not always get there in your mind, but we're trying really hard. I was in your shoes. I never entertained changing the blue slip process, and I hope that never happens. I did meet with the White House counsel's office. I want to thank them for coming over, and I had a very good, productive meeting.
Now we'll hear introductions of our nominees, and beginning with Senator Cardin of Maryland, who's introducing Judge Herson.
Well, Chairman Durbin, Senator Graham, members of the committee, it's a real pleasure to be back before the Judiciary Committee to introduce U.S. Magistrate Judge Brendan Herson, who's been nominated by President Biden to serve on the District Court of Maryland. Senator Van Hollen and I have a process like many of the members of the Senate. We have a bipartisan professional committee that interviews all applicants that are interested in serving in our district court. We have many applications. I must tell you that Judge Herson rose to the top as one of the most qualified individuals we could ever recommend for the District Court of Maryland. So I'm very proud to recommend his nomination along with Senator Van Hollen, and I thank him for his continued public service. He lives in Baltimore, and I must tell you, he has devoted his entire professional career to serving the public, to strengthen our legal system, to strengthen our rule of law. Let me just give you a little bit of background about Judge Herson. He received his undergraduate degree in 2000 from Providence College in Providence, Rhode Island, where he majored in public and community service studies with a minor in Black studies. After college, he served in the Jesuit Volunteer Corps in California as an advocate for the poor and marginalized communities in San Francisco's Tenderloin neighborhood. In 2005, Judge Herson graduated Order of the Coif from the University of Maryland School of Law, an outstanding school of law, since I'm an alumni of that school also. After completing his judicial clerkship in 2007, Judge Herson joined the Office of the Federal Public Defender in Baltimore, where he defended individuals charged with felony and misdemeanor offenses in Maryland's federal court. He was named Senior Litigation Counsel in 2015. In 2017, Judge Herson joined the Office of the Federal Public Defender for the United States Virgin Islands, where he represented people charged with violating federal and territorial laws on the island of St. John, St. Thomas, and St. Croix. In 2008, he returned to the Public Defender's Office in Baltimore, and in February 2022, Judge Herson was sworn in as a United States Magistrate Judge and sits in Baltimore. As a sitting magistrate judge, Judge Herson presides over both preliminary criminal proceedings and civil law suits by consent of the parties, and also coordinates the District of Maryland Social Security Appeals docket. Judge Herson therefore brings remarkable experience to this position, having served as a federal public defender for a decade and a half and now serves as a magistrate judge for over a year. Confirmed he would continue to serve in the same court where he now sits as a magistrate judge and where he's practiced as a public defender for many years. I also want to acknowledge, as we all understand, that public service is a family commitment. I want to welcome many members of his family that are with us today, including his parents, his wife Abby, his daughter Mary, his son Patrick, and other extended families that are here today. We thank them for understanding the sacrifice that Judge Herson makes for his public service.
Thanks, Senator Corden. We'll now recognize Senator Van Hollen, who has just walked through the door. A dramatic entrance as usual. Senator Van Hollen.
Thank you, Mr. Chairman, Ranking Member Graham, members of the committee. I know that Senator Cardin has covered Judge Herson's record well, Magistrate Judge Herson's record well, so I do want to associate myself with all the remarks he made, and I want to just say I strongly encourage this committee to support the President's nomination. In Judge Herson, we have somebody whose peers have repeatedly described as somebody who's deeply committed to ensuring that everybody who comes before him in the courtroom gets a just and fair hearing. And if you look at his record, both as a magistrate judge and his previous record as a public defender, you see that very clearly. In addition to the service he's provided in many other forums. Just to give you an idea of what his colleagues have described him as, a, quote, fountain of empathy, a fountain of knowledge, and a thoroughly good person devoted to Baltimore. In this case, he will be devoted to the people of Maryland and of the United States. I just want to say to him and his family, who I understand have been introduced, congratulations on your nominations. And I fully second Senator Cardin's statement and his endorsement. I urge the committee to act quickly to support the President's nomination.
Thank you, Senator Van Hollen. I'll now recognize Senator Cassidy to introduce Mr. Papillon.
Thank you, Mr. Chairman. It's an honor to introduce Darryl Papillon to the committee today and to recommend him for appointment to the Eastern District of Louisiana. Darryl is an accomplished lawyer, a Louisiana native, a fellow LSU Tiger, and will be an excellent federal judge. I also welcome Mr. Papillon's family here to support him. He's joined by his children, Jude, Anna, Liam, and Julianne, his wife, Lauren, and his sister, Kimberly. And his law partners, Jay Cullins and Abood Thomas, are also here. You know, I'm not an attorney. So way back when I said I'm not going to try and be one, no matter if I slept in a Holiday Inn. And so what I do is I have attorneys, and they go around and ask their fellow attorneys, their peers, who is good? So this is what you hear about Darryl. Intelligent, caring, hardworking, experienced, honest, fair-minded, knows the law. It's clear to me and to everyone that my team spoke to that Darryl has the experience and temperament to be an outstanding federal judge. His knowledge of the law and his thoughtful approach to the law was on display during his time as the president of the Louisiana State Bar Association and as a fellow for the American College for Trial Lawyers. This college is a group of top lawyers, well represented by both sides of the aisle, and who are known for being selected for their temperament and legal expertise. I'm confident that Mr. Papillon's commitment to fairness to all who may come before him and to the law will become clear to the committee during this hearing. I look forward to his approval by the panel and by the entire Senate. Thank you, Mr. Chair. And with that, I yield.
Thanks, Senator Cassidy. And Senator Kennedy, you'll be recognized. And I might say to my colleagues, I know you have a busy schedule if you have to leave, but thank you for coming, joining us today. Senator Kennedy.
Thank you, Mr. Chairman. I have watched, observed Mr. Papillon for years, really decades. We've both been around a while, both in his community and in our courts. He's a former president of our state bar association. He has tried, I think, 33 cases in state court and federal court to verdict. He's been, for the longest time, he was a professor, an adjunct professor at LSU Law School in Baton Rouge. I'm pretty sure, I haven't looked it up, but I'm pretty sure Darrell is a Democrat. I say that because President Biden nominated him. And I mention it only because I have gotten so many letters in support of Mr. Papillon from Republican public officials, including most Republican members of our Louisiana Supreme Court. And this is only a portion of them. The real list of letters that I've gotten in support, you could stand on them and paint the ceiling. That's not much of an exaggeration. Darrell is not a politician. I don't even know if he's ever made any campaign contributions.
That's terrible.
He's not an activist. He's a lawyer. He understands the magistry, the complexity, the nuances, the utility, the beauty of the law. In every community of any size in America, there are always 2, maybe 3 lawyers that I call lawyers. These are lawyers. They're not necessarily the ones in the paper every day, and they're not necessarily the loudest. But these are the lawyers that other lawyers hire if the other lawyers need a lawyer. And they're never more than 2 or 3. And Darrell's one of those lawyers. I mean, he's one of those lawyers that if you're a lawyer and you need a lawyer, doesn't matter what it's for, you're going to call him and say, "What do you think?" So I'm going to support him. Have been supporting him. I hope you will too. He's a real lawyer's lawyer.
Thanks, Senator Kennedy, and I want to personally thank you because I nudged from time to time and urged that you try to find some common ground with the White House, and you and Senator Cassidy have done an extraordinary job of reaching that goal. So thank you for your leadership in that regard.
I like your use of that word nudge, Mr. Chairman. That's very artful.
Thank you. Thanks to all the introducers, I'd like to introduce Jeremy Daniel. He's been nominated to the Northern District of Illinois. A native Chicagoan, Mr. Daniel received his bachelor's degree from Illinois Wesleyan University, which is in the Bloomington-Normal area, his law degree from Loyola University School of Law. He served his country in more ways than one. As an undergraduate student, he served in the Marine Corps as a reservist. After he graduated, he served as a Marine captain and completed tours in Japan and South Korea. Following law school, Mr. Daniel worked in private practice on intellectual property cases for a number of years before clerking for U.S. Judge Virginia Kendall for the Northern District. Since 2014, Mr. Daniel has served as an assistant U.S. attorney in the Northern District. As an assistant U.S. attorney, he has prosecuted a wide range of federal crimes, violations of drug and firearm laws, gang investigations, and financial crimes. Since 2019, Mr. Daniel has served as Deputy Chief of Narcotics and Money Laundering. In addition to investigating and prosecuting his own cases, he also supervises other attorneys in that section. He has a wealth of courtroom experience and a career that has been characterized by public service. I want to welcome him and his family here today. I had a chance to meet him, and I look forward to hearing from Mr. Daniel. I also want to take a moment to thank the Judicial Screening Committee that Senator Duckworth and I established to review candidates for these judgeships. Chaired by former U.S. federal judge David Corr, the committee has done outstanding work, and they thought very highly of Mr. Daniel. Senator Duckworth couldn't join us today, but believe me, she's totally supportive of Mr. Daniels and will have a statement entered into the record. Now, I ask the three nominees if they would please approach the table for their testimony before the committee. Please remain standing for just a moment. If you would raise your right hand. Do you affirm the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth? So help you God. Let the record indicate that all three have answered in the affirmative, which spares us some real headaches. So, Mr. Daniel, I'm going to let you kick it off. Please proceed.
Thank you, Chair Durbin, Ranking Member Graham, and members of the committee for the opportunity to appear before you today. I would like to thank you, Senator Durbin, as well as Senator Duckworth, for recommending me to the President. I would like to thank President Biden for this nomination. I am humbled and honored by it. I would like to introduce the members of my family here with me today, starting with my wife, Silver, and my three daughters. I thank them for their love and support and for the joy that they bring me every day. I would also like to introduce my Aunt Phyllis. Throughout my life, she's been a pillar of support for me. She may not know it, but she's here today as a mother figure to both me and my wife. I'd be remiss if I didn't mention my mother and my mother-in-law. Neither could be here today. We lost my mother to pancreatic cancer in November 2021, and my mother-in-law to colon cancer 3 months later. Our mothers worked hard to provide for and raise their families. My mother, as a single mother and a banquet waitress, raising 5 children on Chicago's West Side, and my mother-in-law, a nurse who immigrated to the United States from Trinidad. I'm forever thankful for their tireless efforts in raising us. Finally, I would like to thank those family members, friends, judges, mentors, colleagues, and staff through the years who have supported me in some form or another. I only hope that they have benefited as much as I have from our interactions. Senators, I welcome your questions and thank you.
Thank you very much, Mr. Daniel. Judge Herson.
Thank you, Chair Durbin, Ranking Member Graham, and all the members of the committee for allowing me to appear before you this morning. I want to first thank President Biden for the trust he has placed in me. I'd also like to thank my home state senators, Senator Ben Cardin, Senator Chris Van Hollen, for supporting my nomination and for their kind words today. I'd like to thank my many amazing former colleagues, particularly those at the Federal Public Defender in Maryland and in the United States Virgin Islands, as well as my current colleagues on the United States District Court for the District of Maryland. And I'd particularly like to recognize my chamber's staff and my law clerks. I'd like to acknowledge the Honorable Margaret B. Seymour and her career law clerk, Deborah Morgan. They provided stellar role models for me and for dozens of other law clerks who had the privilege to serve in Judge Seymour's chambers. To my friends in Baltimore and beyond, I want to thank you for all you have given me. I'm also blessed to come from a very large family, some of whom are here today, others are watching at home. I wish I had the time to list all my siblings, my in-laws, my nieces, nephews, aunts, and uncles by name, but I don't. But please know that I love each of you, and I wouldn't be here today without you. I would like to personally acknowledge my amazing in-laws, Mike and Martha, who are watching from home. I'm also blessed to have my parents here, Dan and Meg. I credit my parents with inspiring me to pursue what has been a richly rewarding career in public service. I'd also like to thank my beautiful children who sit behind me and made what I'm sure was a very tough decision to not go to school today, but to come here and sit with me. I love you both, and I'm very proud of you. And finally, I'd like to acknowledge my wife, Abby. Abby is my partner in service and in life. Her commitment to our family and to me, all while juggling her own career, makes it possible for me to sit here today. I love you, and I thank you so much for always being in my corner. Thank you.
Thank you, Judge Herson. Mr. Papillon?
Thank you. Good morning, Chairman Durbin, Ranking Member Graham, members of the committee. I would like to express my sincere thanks to President Biden for nominating me, and I'm tremendously grateful to my home state senators, John Kennedy and Bill Cassidy, for recommending me to the President and for the kind words they've said today. I am deeply honored to have been nominated to serve my country as a United States District Judge. With me today are my wife, Lauren, and 4 of our 5 children, all of whom are missing school. Jude is a college senior, Anna, a college sophomore, Liam, a 6th grader, Juliana, a 3rd grader. Last but not least, hopefully behaving and for his grandparents and watching from home is our 1-year-old, VL. Also here with me today are my sister, Kimberly Charles, and my law partners and dear friends, Jay Cullens and Abood Thomas. With me in my heart are my late father, Francis Papillon, who inspired me to become a lawyer, and my late wife, Shirley. Their sacrifices, support, and example are a substantial factor in why I sit before you today. Also with me in spirit and love is my mother, Rita, who is watching from home, my in-laws, Warren and Arlene Bird, Marita Caesar, and all the members of our family. Finally, I say, bonjour à la Louisiane, and good morning in Louisiana to my mentor, Ed Walters, and everyone who mentored me, and all of my colleagues at Walters, Papillon, Thomas Cullens, my friends from the federal and state bench and bar, and the entire legal community in my home state, and most of all, my students at the LSU Law School. Senators, I'm happy to answer your questions.
Thank you very much. You wouldn't have reached this moment and be seated at this table had you not been able to check some important boxes in terms of training, education, life experience. Seeking a position which is a lifetime appointment, which is rare under our federal law, and it certainly calls into question what kind of role models you may have in your mind. Each of you has appeared before many judges over the course of your career and undoubtedly drawn conclusions about those who were your favorites and those who weren't, whether they ruled against you or for you. So starting with Mr. Papillon, you can name names if you wish, but in your mind, what is the role model of a federal judge that you think about as you aspire to this position?
Thank you, Chairman Durbin. There are many judges, and I've had the opportunity in my career to be before many. I believe the universal theme is hard work, judges who are fair and honest, and who treat both sides equally and with respect, who do their homework, who study the law, and essentially work to just decide cases based on the merits, and that's what I would hope to do.
Magistrate Herson, you've been on both sides of the bench.
I have, and I have in my career had the privilege of appearing before dozens of federal judges and many state judges too. And I will name a name, Judge Margaret Seymour, who I was blessed to clerk for in Columbia, South Carolina, has always been a role model for me. Her temperament, her commitment to the law, and the way that she made sure that every single person who came into her courtroom knew what was happening and why it was happening. And that's a lesson that I take to the bench every single day that I'm privileged to serve as a magistrate judge in Maryland. And if I were so fortunate as to be confirmed, I would take that to the district court bench as well.
Thank you. Mr. Daniel?
Chair Durbin, I've seen many of the qualities in the judges that my colleagues here on the panel have seen in their respective districts on the bench in my district. I would like to add that one of the best qualities I've had in the judges I've seen in the judges I've appeared in front of were in those instances where the judge ruled against me and leaving the courtroom with full respect and appreciation for the decision. I think it's imperative for judges to be impartial and to be willing to explain their positions. And in that, that's what we all ask of our legal system. And I'd be remiss not to mention Judge Kendall, whom I clerked for, and has helped me tremendously in patterning my career and my practice.
I'm glad you mentioned Judge Kendall. She's, of course, a nominee that we were able to help and support through this committee and was one of the early appointments when I was a member of this Judiciary Committee. So thank you for that. Senator Graham.
Congratulations to y'all. A lot of nice things said about each of you, and I'm sure they're deserved. And to your families, congratulations. It's a very big deal. Mr. Daniel, what'd you do in the Marines?
When I was enlisted in the reserves, I was a motor vehicle operator. When I became an officer after graduation, I was a combat engineer officer, ranking member.
That's excellent. So you've been in the prosecution lane, U.S. Attorney's Office, is that correct?
Correct.
So what's your interaction in terms of the fentanyl problem in the country? Have you had much of a chance to deal with fentanyl cases?
I have, Senator. Back in 2014, I believe it was, I was assigned an investigation following a rash of overdose deaths in Chicago. That investigation turned into a year-long wire investigation where we were able to identify the source of that fentanyl that resulted in the overdoses and then charge the organization responsible for distributing it by organization, the organization in the Chicago area.
So during that, why did these drug groups, cartels, organizations, why do they put fentanyl in drugs without people knowing? What conclusion did you come to?
Senator, this investigation I'm referring to, in that investigation, we learned for the first time that it was being mixed locally.
Right.
My understanding, based on that investigation and from some of the testimony we received from witnesses and some of the defendants who were both users and distributors, were that the fentanyl was being added to increase the potency of the drugs. It's more profitable to dilute substances, and when they dilute, users may complain that the drugs are weak, in their words, and so the fentanyl is added, oftentimes unknowingly, unknowing to the users to increase the potency.
So Secretary Mayorkas said before the committee that he thought fentanyl problem in America is one of the greatest threats we face as a nation. Do you agree with that?
I agree that fentanyl poses a risk to all who encounter it. I've had cases involving fentanyl-related deaths, and it is very dangerous, Senator.
Okay. Do you agree with that, Mr. Herson?
I agree with my colleague that it is a significant issue that faces this country, and it's one that I see every day in my courtroom.
Yeah, so what kind of cases do you have involving fentanyl?
Well, as a United States magistrate judge, we handle the preliminary proceedings in all criminal cases. And sitting in Baltimore, which is a city like many others in this country that faces a significant heroin and fentanyl problem, we do see a lot of drug and drug-related cases.
How would you describe it in terms of the scope of the problem for Baltimore? Is it at the top of the list, middle of the list?
I'm not familiar with numbers nationwide, but I can say anecdotally it's a significant issue in our city, and it's one that when I am faced with cases presenting defendants charged with distribution of drugs, oftentimes they themselves are users of drugs. And I can say without any hesitation that our pretrial services department works very hard to try to find treatment for those individuals. And I know firsthand there are a large number of people in the city working very hard to address the problem from the top to the bottom.
Where does most of the fentanyl come from in Baltimore? Do you know?
I do not know. I know as much as anyone who reads the paper. I understand there are foreign sources. I hear from my colleague there may be domestic sources.
Okay, but would you understand why this committee would want to do more, both of you, to deter fentanyl use and distribution? Does that make sense to you, given your interaction with the drug?
Thank you, Ranking Member Graham. I think I can't speak for what the committee would want to do, Ranking Member, but my office in Chicago, the U.S. Attorney's Office for the Northern District of Illinois, has identified fentanyl as a priority, and since that case back in 2014, it's remained a priority.
Thank you. Mr. Papillon, last question. On occasion, a district court judge will issue an order that affects the entire nation. Under what circumstances do you think that's appropriate? and how would you handle that issue?
Thank you, Senator. National injunctions are governed by Rule 65 of the Federal Rules of Civil Procedure. It's a very serious issue. In the Fifth Circuit has held that district judges have the authority, because they are judges of the United States, to issue those. I can tell you that if faced with that, I would study it very carefully, follow the applicable precedents, and try to make the right decision, because obviously when one issues an injunction beyond the four corners of a case, that is of tremendous magnitude and is to be treated very seriously, and I would.
Senator Padilla?
Thank you, Mr. Chair. Congratulations to the three of you for the nominations, and appreciate your participation in the hearing today. You know, the topic of judicial ethics is one that's top of mind right now. I mean, for me, I know for several of my colleagues, and I think for people across the country. And I know I'm disturbed by the recent reports detailing potentially unethical, even potentially illegal conduct at the highest levels of our judiciary. I mean, it should go without saying that judges at all levels should be held to strict and enforceable ethical standards. I have a question for you, Mr. Papillon. While you were serving as special master, you identified a potential conflict of interest and made the decision to recuse yourself from a matter. Why do you believe it's important that judges take the responsibility of recusing themselves when there's even just the potential for a conflict of interest?
Thank you, Senator. As a federal judge, as a judge of any kind, but particularly in this context, there are canons that govern our conduct even as nominees. And the reason, I believe, for these canons is to promote confidence in our judiciary. And so the public needs to understand that judges who will decide their cases are fair, impartial, and won't pick favorites of any kind on either side. And that would be what I would do if I were so fortunate as to be confirmed.
So thank you. I mean, it's, I'm sure, additional reasons, but confidence in the judiciary, confidence in outcomes, confidence in the system overall is important. Another dynamic that this committee has been prioritizing to help strengthen confidence in the judiciary is by advancing diversity, not just in diversity in ethnic or racial backgrounds, but in life experience, work, and professional experience of the nominees that are recommended to the White House, that are nominated by the White House, that are considered and confirmed by the committee and the Senate. But I want to take this prioritization of diversity one step further. I mean, as we know, judges are not the only ones who work in courtrooms. Judges are assisted by a wide array of assistants, particularly law clerks. And as I believe each one of you can attest, serving as a law clerk can be pivotal. A good experience, a good assignment can be pivotal in a successful longer-term career, whether it's in the public sector or the private sector. And so I'd like to hear from each of you if you agree with my premise that improving diversity is part of improving the judiciary and public confidence in the judiciary, and what you might do, if confirmed, to advance diversity in your courtroom. So we'll start with Mr. Daniel.
Thank you, Senator. The first time I encountered the benefits of diversity was when I was an officer in the Marine Corps. We drew Marines from all over the country with varied experiences, and you'd be surprised at how wonderful it is to ask a group of people, has anyone ever seen something like this? And having someone raise their hand because they just had a different life experience. So I've valued diversity of all sorts since, and I think it's important. As I was set on my current path as extern for a judge in the Northern District of Illinois. And I was introduced to that externship through the ABA's Judicial Intern Opportunity Program. I later went on to clerk. And as far as implementation, I think you just have to be cognizant of where you're looking, because opportunity is often the touchstone of increasing diversity, just making sure that you're identifying qualified candidates from all areas.
Thank you very much. I agree that law clerk service is critically important. It was important to me in my career, and I wouldn't be where I was without my own law clerk, Nancy Dordal, who's actually sitting behind me. I agree with both of my colleagues, and I think it really starts with the judge and casting a wide net, getting out in the community, meeting with law students, doing mock interviews with law students, trying to generate interest in the position, and keeping a wide net for diversity of all kinds, geographic, the school that you attended, your career ambitions. And that's something I've tried to do as a United States magistrate judge and would continue to do if I was blessed to become a district court judge.
Thank you.
One of the great highlights of my career was to clerk for Justice Catherine Kimball of the Louisiana Supreme Court, and I know that diversity was important to her. What I would do, Senator, is I would work to find the best and the brightest law clerks that I could, and that would include, as my colleagues have said, casting a very wide net to get the best and the brightest people from every background possible.
Thank you all very much. Thank you, Mr. Chair.
Thank you, Senator Padilla. Senator Kennedy.
Thank you, Mr. Chairman. Congratulations, gentlemen. Mr. Papillon, tell me the definition of a motion in limine.
Motion in limine, in some law books it doesn't exist, Senator, but what it is it is a motion filed in advance of trial to get a ruling in limine, which means in advance of some issue that may come up in the trial, usually an evidentiary issue.
I thought you might know.
Thank you.
Judge Herson, explain to me the various definitions that the U.S. Supreme Court has used to define a fundamental right.
In Glucksberg, and even recently in Dobbs, the Supreme Court has really focused on two major issues. One, whether the right in question is deeply rooted in our history and tradition. And the court is also focused on whether it is implicit in the concept of ordered liberty. And I also believe that in Glucksberg they describe the need for the right to be clearly defined.
How does that relate to the discussion in Griswold of a penumbra?
Well, obviously, Griswold, as you state, points out this concept of the penumbra, rights that are not explicitly enumerated, but that the court has otherwise found. As a sitting magistrate judge, and if I was fortunate to become a district judge, I would, of course, follow the guidance of the Supreme Court, who has identified just a few, relatively small number of those rights. Obviously, the right to privacy, perhaps being the most well-known.
Well, can you have, what has the Supreme Court said about the existence of a fundamental right that is not part of our history and tradition? For example, when the court delved into the Second Amendment, it was really, the opinions were almost written as if they were historians as opposed to judges, but part of our history and tradition was a fundamental part of their discussion. Does the right have to be part of our history and tradition to be fundamental?
Well, I can say this, that in Heller, McDonald, and Bruin, that was the focus. That's what the court looked at. Now, there are other cases throughout history that have recognized a few other rights, the right to marry, for example. And I can't speak to the specific methodology that was used, but I will say, at least in the Second Amendment context, that focus on history was critically important.
Okay. All right. Let me move to Mr. Daniel. Can a police officer well, let me try this another way. If I'm walking down the street and a police officer wants to stop and talk to me, can he just stop and talk to me for any reason?
Senator, you can seek your consent to stop and talk to you.
What if I don't consent?
If you don't consent, then the officer needs to have a reasonable articulable suspicion that a crime has been committed, will be committed, and be able to articulate that to justify the stop.
Okay. Then how come police officers can set up a roadblock and stop 500 people to see if they have liability insurance?
My understanding is that the Supreme Court has ruled that those types of stops, when generally applied, are conducive to good order and policing.
Why? They're still stops, aren't they?
Senator, in my 8.5 years as a prosecutor, I've not had to litigate the adequacy.
I know. I'm just asking you what you think. I mean, isn't that pretty intrusive? What if I'm in a hurry to pick up my kid from school and I don't have time to wait for 10 minutes? And I don't want to wait anyway. Why? If a cop can't just stop me on the street, why can they stop me and check my insurance?
Senator, as far as my personal belief, I haven't encountered that.
I'm just asking you legally, why can they do that?
Again, I haven't encountered that issue, so I don't have the research on that, Senator.
Okay. Thank you. Thank you, gentlemen.
Senator Welch?
Thank you. Thank you all. It's really pretty nice to have these folks here with their families and the history, and I appreciate all of you introducing them and acknowledging the big role that they played. A couple of you suggested it might be a burden for some of your kids to miss school. I think you might be fibbing on that, but it's good to have you, and congratulations on your nominations, and congratulations on all the public service that you provided. Mr. Herson, I was a public defender and then went into private practice like you, Mr. Papillon. And just sometimes there's folks in the public that get a little concerned about a public defender and make the connection that if you're assigned to a client who's done something that you obviously think is terrible, how is it you can do it? And I've had to answer that question many times. You're sitting next to a prosecutor, and I guess you were a former prosecutor as well. You feeling a little uncomfortable? You want to just give us an answer of how you contend with that?
Well, first, I'm not feeling uncomfortable at all. I'm very happy to be sitting between these two gentlemen. And I, every day as a United States magistrate judge, sit on a court that has both former prosecutors and former public defenders, and I can say we get along quite well. As for my former career as an advocate in the public defender's office, I too encountered that question quite a bit. But I'll tell you that the answer that I gave was always that my duty, my obligation, was to uphold the Sixth Amendment, hold the government to their burden, and ensure that not just my client's rights, but in that sense, everyone's rights were protected.
Right.
It also brought me in touch with all sorts of aspects of the criminal justice system, from pretrial service officers, probation officers, corrections officers, the United States Marshals, and of course prosecutors. And those relationships that I built during those days have helped me so much as a judge, which, as you know, is a very different role.
Right. Well, thank you, Mr. Daniel. I'm sure you had to work with a lot of public defenders when you were a prosecutor, and you're on the other side of it. You're prosecuting. Sometimes prosecutors go overboard, but most of the time they're upholding the public good and law and order. Maybe you could comment on your role in the criminal justice system, making certain that people get a fair trial.
Thank you, Senator. The criminal justice process begins with the investigative agencies and the prosecutor's office. And in the Northern District of Illinois, we make a point to make sure that we're thorough in our collection of evidence and that we identify individuals and charges as appropriate. We appreciate and understand that it is a significant thing to charge someone federally. And so we are very diligent and careful in our approach to
I
prosecution.
appreciate that, because when you have that awesome power as a prosecutor, the quality I've admired in the prosecutors I've watched is restraint. They're really careful about the use of that authority. You seem to be reflecting that.
It's important, Senator. There's also an imperative to keep victims in mind, as well as the overall common good. At the end of the day, I think prosecutors, federal defenders, all involved in the process, including judges, are just looking to get to a just result, or they should be.
Thank you. And I just want to end with you, Mr. Papillon. You were a defense attorney insurance defense attorney, as I understand, for a while, and then you became a plaintiff's attorney. One of the challenges we have is getting access to the courts that are backlogged in many situations, so people who have claims can have them heard. Any thoughts on what holds up, how to facilitate access to the courts for civil litigation?
Well, I think that if one of the best ways is to have scheduling orders and have judges really focus on trying to move the cases in their particular court. The Eastern District of Louisiana, the court to which I've been nominated, does a fantastic job of that, and I would hope to be a part of it.
So there's a big administrative role that the presiding judge has to play to push the attorneys along to get to an outcome.
Yes.
And you're prepared, and from having served on both sides, plaintiff and defendant.
That's, I believe, absolutely my job if I were so fortunate as to be confirmed to really move cases to conclusion and give people their day in court.
Well, thank you all, and congratulations on your nomination. Thank you.
Thanks, Senator Welch. Senator Lee.
Thanks to all of you for being here today. Judge, Mr. Papillon, let's start with you. Got ahead of myself there. Tell me about the Erie Doctrine. What's your understanding of that doctrine?
Thank you, Senator. The Erie Doctrine is a doctrine that when a federal district court is sitting in diversity jurisdiction, it applies state substantive law, and it applies the federal procedural law, the federal rules of civil procedure, the federal rules of evidence.
What's worse, in your view, invalidating as unconstitutional a statute whose unconstitutionality is sketchy, or upholding a statute whose application is in fact unconstitutional?
That's a difficult question, Senator. Obviously, if a law is unconstitutional, it is inappropriate and is something that should, going back to Marbury versus Madison in a different context, obviously.
Suppose we're talking about an as-applied challenge. It'll make it a little simpler.
Yeah. Can you tell me what you're asking?
An as-applied challenge, meaning it's you're not dealing with something that's facially unconstitutional. So what's worse in that circumstance? Upholding the application of a statute as to which it might be an unconstitutional application and is, or improperly holding something unconstitutional as applied when it's not. Is either one more defensible than the other?
I don't believe either is defensible, so it's hard to, when things are indefensible, it's hard to rank them. So I would say they're both wrong.
Yep. A few years ago, there was an executive order issued by Governor John Bell Edwards dealing with COVID in a lawsuit involving Pastor Tony Spell. The pastor argued, among other things, that he was protected by the First Amendment and that the law couldn't apply to his decision to hold church services. When you were asked about this at oral argument, you were reported to have said, quote, "The law is not about one person, whether a pastor or a churchgoer. We're a nation and a state of laws." Would you make that same argument today? Or was that, did you in fact make that argument?
That sounds like a familiar argument. I think I would argue a lot of things differently, I think, in that particular case. That was a very difficult and challenging case for the state of Louisiana and for religious liberty, Senator.
Okay. You said that sounds like a familiar argument. Sounds like something you might have said. In other words,
Yes.
why is that appropriate? I mean, the First Amendment is there almost entirely for people making the argument as just one person, as the challenger. The whole reason we even need it is because it's there to protect people in expressing unpopular beliefs, in believing unpopular things. And so I don't understand why you would think that was a good argument to make, that the law isn't about one person. We're a nation and a state of laws. I mean, that's the whole point, is to, in some circumstances, penetrate the law to protect the individual, is it not?
Senator, in that particular case, to add context, this was a case that the state of Louisiana brought against a man of faith during the pandemic.
Who just wanted to have church. He
Yes.
wanted to have church services, and you prosecuted him for that.
And there was an executive order issued by the governor at a time, as you're aware, when the Lukumi decision and the Jacobson versus Massachusetts decisions were not necessarily, in that particular context, the most helpful tools for states. And my role
Right, not the most helpful tools because they went against the state's interests.
in some contexts, but in other contexts, the Fifth Circuit, for example, used it in another way. And so when states were forming their response on the ground, it would have been wonderful to have, for example, the benefit of Tannen versus Newsom at the time that this prosecution was brought.
Okay. That part is concerning to me because it's the whole reason we've got them. It's the only reason we have them. Judge Hersom, what's the standard for diversity jurisdiction?
In federal court, the diversity jurisdiction. Forgive me, I pledge not to do that. In federal court, the parties need to be from separate states, and the amount of controversy needs to be $75,000 or more.
Okay. Thank you very much. I see my time's expired.
Thank you very much, Senator Lee. We're going to make an exception to our procedure because our colleague, Senator Blumenthal, was injured last week, has returned to Washington to duty with a broken femur, and is asked for permission to ask questions from his office. Senator Blumenthal, are you on board?
I am on board, and thank you so much, Mr. Chairman, for accommodating me. I've been at a couple of other hearings this morning, and really appreciate the opportunity to question the very qualified candidates and nominees for the court at a time when I think our public trust and credibility in the judiciary is more threatened than ever due to recent controversy involving the Supreme Court. And I thank the chairman for committing to have hearings on a standard of accountability and ethics for the Supreme Court. I'd like to ask each of these nominees what you will do to assure that trust and credibility in the judiciary is preserved and, in fact, enhanced, both in your private dealings and in the appearance of ethical standards in the way you conduct yourself.
Would you like to direct that question to any particular nominee?
To the entire panel, to each of the nominees.
Mr. Papillon, why don't you start?
Thank you. Thank you, Senator. If I were so fortunate as to be confirmed to be a U.S. District Judge, I would work every day to uphold the integrity of the judiciary. We have a strict code of ethics that I would follow scrupulously, and I would try to conduct my dealings in all ways to comport with that, to inspire and to promote confidence in the federal judiciary in the way that I would run my courtroom, the way that I would treat litigants, the way that I would deal with the world outside of court as well. Thank you.
Magistrate Herson?
Thank you. As a sitting magistrate judge, I already followed the code of ethics, the judicial canons. And I do agree that trust in the courts is very important. And every day that I do my job, I do my best to ensure that I follow all recusal requirements and that I interact with the litigants and the public in a way that does nothing but engender trust. And I agree with everything else that my colleague, Mr. Papillon, said.
Mr. Daniel?
Thank you. I would, of course, follow the Code of Judicial Ethics. I would conduct myself in a way that comports with the position. I think it's an important position in the nation, and that the nation, I think it's imperative that the nation have trust in its courts. And it would be incumbent upon me to conduct myself in a manner that was beyond reproach in all respects.
Thank you, each of you, for your commitment to follow those high ethical standards, not just the ethical standards that apply to all district court judges and all courts of appeal judges, but also a standard of integrity that comports with public trust and credibility, which I think is so very important at this point in our nation's history. And I think your testimony is very, very reassuring to me that the awareness of the importance of those standards will be with you when you are confirmed, as I hope you will be, to the United States District Court. Thank you very much, Mr. Chairman.
Thank you, Senator Blumenthal. Senator Blackburn?
Thank you, Mr. Chairman. Congratulations to each of you and to your families. We're delighted that y'all are here with us today. Mr. Papillon, I want to come to you and go back to this case with Pastor Spell. That is a thing that concerns me because at the time, Governor Edwards thanked the protesters. So it was okay for protesters to assemble in Louisiana, but not okay for people of faith to assemble. So that is, in my opinion, and I would think to you, that that would have been the unconstitutional part of this approach of going against Pastor Spell and ruling against Pastor Spell. So what I'd like to hear from you is why you would see this as not being that restriction on free speech. Why did you think that was acceptable, and what was the legal basis that you went to for that decision?
Thank you, Senator. I'm not familiar with the part about the protesters, but I'm very familiar with the Spell
Well,
case.
it's a quote that I have in front of me. He thanked the protesters at the time and stated that they were appropriately expressing their concerns and exercising their First Amendment rights.
All right. Again, it's just something my role was in the Spell prosecution, but let me explain that, if I may. It is that in the very early stages of the pandemic, states were faced with the very difficult collision of the very important right to religious expression and the state's power to protect the public. And the law clearly protects religious liberty, but it also gave the state the power that it did. And we later got guidance from the United States Supreme Court in some very important cases. And I believe that had those cases been decided earlier, the order that the governor wrote, which I didn't write, would likely have been written differently. And I didn't choose to prosecute the pastor, but as a lawyer, I represented my client, the state of Louisiana. If I were to be confirmed as a United States district judge, I would very scrupulously follow the First Amendment and the tests that our Supreme Court and the U.S. Fifth Circuit have made very clear that when a secular institution is treated more favorably than religion, strict scrutiny applies, and the state needs to show that whatever remedy it wants to apply is narrowly tailored to achieve the result. And we can't assume the worst. as the courts have said, when people go to church, and the best when they go someplace else like work or the mall. And that is today, I think, a very clear principle of law that I would follow as a judge.
Okay, well, I will tell you that's the thing that really concerns me, is the way that I appreciate your explanation, but the free exercise of religion is very important to Tennesseans. It's important to the religious organizations that call Nashville, Tennessee home. And I'm sure you're aware that there are many. And to have a case where it seems there is a subjective opinion that allows one type place of gathering, allows another type place of gathering, but disadvantages and disallows the exercise of religion, that causes tremendous concern. It seems like an inconsistency of the approach. And as I've reviewed your record, have been concerned about that. My time has just about expired. Mr. Herson, I'm going to come to you and Mr. Daniels with a written question pertaining to your judicial philosophy and your approach on some issues. I was concerned, Mr. Herson, of the remarks you made to Senator Graham on fentanyl and the awareness of fentanyl and the impact that has on our community. Thank you, Mr. Chairman.
Thank you, Senator Blackburn, and thank you to the nominees. Senator Welch, did you have any follow-up questions? Thank you very much for being here this morning. The process will continue from this point, and you may receive written questions in a few days. Prompt reply gives us an opportunity to move forward ourselves. I thank you all for being here, and especially thank your family and friends for the sacrifice of joining you and supporting you. And we look forward to pursuing your nominations to a satisfactory conclusion as quickly as possible. This meeting of the Senate Judiciary Committee stands adjourned.